A few weeks ago, we shared our special interim report, but now it's time for the main event, our complete June news roundup. First up, the Law Commission's consultation regarding appeals reform has just concluded. We'll break down what was included, what was omitted, and what we can expect next. We also have new updates from the CCRC, including some significant resignations and the potential implications moving forward. At the Court of Appeal, a new door has closed. Colin Campbell, formerly known as Norris, has faced yet another dismissed appeal. Additionally, we'll provide the latest updates regarding the Lucy Letby case. And conclude with a powerful event on joint enterprise, hosted by Appeal.
I'm Leah. My boyfriend's mate's been handing himself in. To tell the truth, he knows it was only him. Let's go to the police station. We need to give witness statements to tell him. We go to the police station, and the moment we walk in, the police take us into the back. We're arresting you on suspicion of murder.
Now, I'm Leah. 4 of us in the dock for murder. I weren't even there that night. I didn't know about it until the next day. Somebody's owned up to it, but I'm convicted of murder. Joint enterprise, life sentence.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. As anticipated, we are kicking off today's news with an update on the Law Commission's appeals reform. After months of deliberation, we have officially submitted our response, and you can now read the full document on our website under reform proposals. Now, let's be upfront. We didn't answer all 104 questions. Why? Well, partly due to limited resources and partly because some topics fell outside of our area of expertise. But we focused our energy where it matters most for our community. Appeals against Crown Court convictions, the role of the Criminal Cases Review Commission, and the issue of miscarriages of justice compensation. You might remember our trio of videos on reshaping the appeal process, where we outlined key points from our proposed response. But here is what's new. For the first time, we have taken a deep dive into the way CCRC commissioners are appointed, a crucial issue we have never tackled on this channel until now. We believe that real justice reform hinges on independent and effective leadership. However, the CCRC must be empowered to challenge injustice head on. That means top-down reform, starting with how commissioners are appointed. These individuals have the final say on whether a case is reviewed or sent back to the courts. Their power is immense, so their selection must be free from political influence. Speaking of leadership, you may have seen the headlines. On the 2nd of July 2025, the CCRC announced the resignation of Kneller, who served as chief executive since 2013. Dame Vera Baird, the interim chair, acknowledged the urgent need to restore public trust in the organisation. Amanda Pearce will now step in as interim chief executive. Now, while we welcome this resignation and even raised serious concerns about Ms. Kneller's leadership during the Justice Committee session in May, we must be clear. Individual resignation will not fix systemic failure. To truly rebuild the CCRC as a vehicle for justice, we need more than new faces. We need a radically new structure. That includes diversifying commissioner appointments by bringing in people with lived experience, defense lawyers, grassroots campaigners, and investigative journalists. And crucially, removing appointment power from the Ministry of Justice and placing it with an independent multi-stakeholder panel. Real justice demands more than procedure. It needs independent and bold leadership at the heart of the CCRC. Without that, it's just bureaucracy in disguise. Got any thoughts? Drop them in the comments below. We want to hear from you. Now, as you know, the Law Commission's consultation officially closed on the 27th of June. So what happens now? We are in a bit of a waiting game. The Law Commission is set to publish its final report, complete with recommendations, sometime next year. Until then, all eyes are on how they will weigh the responses and whether the voices pushing for real reform, like ours and yours, will influence the direction of change. That's why it's so important to keep these conversations alive. As we said earlier, real justice demands more than just bureaucracy. It needs independence and courage at its core. And if you got thoughts on this, don't hold back. Share them in the comments below. Your perspective matters. Turning now to the Court of Appeal. In our previous news update, we reported on the case of Colin Campbell, formerly known as Norris, which began on the 6th of May 2025 and, as you know, now has concluded. At the time, we were awaiting the Court of Appeal's decision, and that judgment was finally handed down on the 26th of June 2025. The outcome, the court was unequivocal. We have no doubt about the safety of any of the 5 convictions. The appeals are dismissed. I had to admit it's always unsettling to read such absolute language, especially in cases that hinge on complex, often disputed medical evidence. When expert witnesses themselves cannot agree, one has to wonder how judges without medical training can claim such certainty. It raises a broader concern. Is justice really being served when the science is uncertain, yet the verdicts are so final? Still, the judges seem to reassure themselves and perhaps the public with the familiar legal distinction they cite at paragraph 64 of their judgment. It is for this court to determine whether the conviction is safe, not whether the accused is guilty. While that may offer some legal clarity, it doesn't always ease the moral unease this decision can leave behind, especially in cases that involve deeply technical evidence and serious questions of fairness, reiterating Steve Phelps' point reported in our last week podcast that the Court of Appeal is a court of law, not a court of justice. We are not here to claim definitely that the Court of Appeal was right or wrong in its decision on the Colin Campbell's case. What we do know is that the evidence remains, in our view, deeply contested. There are arguments on both sides, and crucial aspects of the case rest on scientific uncertainty and procedural flaws. Consider the case of Miss Ethel Hall. While all experts agreed that her death was consistent with insulin poisoning based on the tests available at the time, it is undisputed that those tests did not meet the gold standard of forensic toxicology. Specifically, the analysis lacked the use of the more precise confirmatory methods such as mass spectrometry to detect synthetic insulin, and it failed to follow the strict chain of custody procedure essential to reliable forensic evidence. In the absence of these safeguards, the credibility of this key piece of evidence is significantly weakened. But even if we were to accept the test results at face value, a larger question still remains. How was Colin Campbell identified as the prime suspect in the first place? Other staff members had access to the patients in question, and the working environment at the hospital was described as lacking proper record keeping. Major failings in stock control procedures were highlighted by the defense at the time of the trial, especially for non-controlled medication like insulin. In such a context, claims that insulin vials were missing are highly unreliable and fall far short of the evidentiary standards required in a case of this magnitude. In short, the combination of an uncertain science, flawed investigative assumptions, and procedural irregularities should at least prompt a deeper level of scrutiny. When a person's life and liberty are at stake, especially in cases involving complex medical interpretation, justice demands more than circumstantial certainty. It demands transparency, rigor, and humility in the face of doubt. Should the justice system rely on uncertainty when expert scientific dissent exists? Let me know in the comments below. Staying on the theme of nursing and contested expert opinion, we now turn to the high-profile case of Lucy Letby. This case continues to unfold with multiple investigations and legal proceedings still ongoing, including a public inquiry and multiple active police investigations. The search for accountability is far from over. Let's take a closer look at the latest development in this case. Back in our April news report, we shared that Letby's barrister Mark MacDonald had personally submitted a formal application to the CCRC. Since then, several significant announcements have emerged from different directions. To begin with, on the 22nd of May 2025, it was revealed that the report by Lady Justice Thirlwell, originally expected in November 2025, has now been delayed, with publication now anticipated in early 2026. Meanwhile, former Health Secretary Sir Jeremy Hunt has added his voice to the growing political pressure for urgent re-examination of the case. Speaking on Good Morning Britain, he urged the CCRC to get their skates on and move swiftly with the review, emphasizing the urgency of revisiting the case without further delay.
Sir Jeremy Hunt is calling for an urgent re-examination of the Lucy Letby case after an international panel of experts presented evidence that the baby's deaths and injuries were due to natural causes or errors in medical care. Is it your worry that in this case an individual has been scapegoated, possibly, for what we now know in other places were more systemic issues in quality of care?
Spot on, Ed. That is exactly the worry, because every day in the NHS we have 3 baby deaths, tragically, and about 5 stillbirths. And these are absolutely awful moments, and often they are caused by medical error. They could have been avoided if things had been done differently. And if that's happened in this case at the Countess of Chester, then what we need to do is to learn why it happened and make sure we learn the lessons so that it's not repeated. The reason why I think they need to do that review is because we've had these 14 experts led by Professor Shu Lee from the University of Toronto, someone completely independent. On that team were people like Professor Nina Modi, who was president of the Royal College of Paediatrics and Child Health when I was Health Secretary. These are people who've got no personal or financial interest in the case, but they are saying that there is no medical evidence in the 17 deaths that were examined in the trial of what they call malfeasance, of malicious intent. And so if they are saying that, then I really think we need to do this. Now, the key issue is that the Criminal Cases Review Commission is unbelievably slow. So what I'm saying is they need to really get their skates on, because this is such a big issue for the families involved. It's causing them such agony. We all want to know an answer, but we need to find out quickly.
As far as wider ongoing investigations around the case are concerned, new developments followed on the 30th of June 2025, when Cheshire Constabulary announced that 3 former senior executives from the NHS hospital where Lucy Letby once worked have been arrested on suspicion of gross negligence manslaughter. As previously reported, a corporate manslaughter investigation into the Countess of Chester Hospital began in October 2023. In March 2025, the scope of that investigation was formally widened to include potential charges of gross negligence manslaughter. Unlike corporate manslaughter, which targets failings at an organizational level, gross negligence manslaughter focuses on the action or inaction of individuals whose conduct may have fallen so far below acceptable standards that it resulted in loss of life. The individuals whose name had not been publicly released were in leadership positions at the Countess of Chester Hospital between 2015 and 2016. Their arrests mark a significant development in the ongoing police investigation into the wider circumstances surrounding the deaths and possible systemic failings at the hospital. All 3 have been released on bail pending further inquiries. Just days later, on the 2nd of July 2025, news broke that Cheshire Police had asked the Crown Prosecution Service to consider additional charges against Lucy Letby. According to The Guardian, the CPS confirmed on that same day that it is reviewing potential further charges linked to alleged offences at both the Countess of Chester Hospital and the Liverpool Women's Hospital, both hospitals where Lucy Letby worked. It is understood that evidence from more than 6 additional cases has been submitted to prosecutors for consideration. To be perfectly honest, I found myself uncertain about what to make of all of this. On one hand, we see medical experts, politicians, and bereaved families deeply divided, some urgently calling for renewed scrutiny, others warning that endless legal proceedings risk delaying the real justice that the system owes them. But what stands out to me is that the authorities' continued push for further investigations seems less like a pursuit of truth and justice and more like an attempt to reinforce the appearance of certainty, to reaffirm the robustness of their original investigation and convictions, rather than engage in a meaningful, open reassessment. If the goal is truly justice, then the focus should not be on defending institutional decisions, but on following the evidence wherever it leads and ensuring a process grounded in transparency, humility, and care for all those affected. And what about you? I'd love to hear your take. Share your thoughts in the comments below and let's keep this important conversation going. And finally, I want to reflect on an event that Barbara and I attended on the 26th of June 2025 in London. One I deliberately left for last because of its profound impact. The focus was on the enduring and deeply troubling issue of joint enterprise, a legal doctrine that continues to disproportionately affect young people, particularly from marginalized communities. Despite recent shifts in case law and ongoing debates at both legal and political levels, calling for greater clarity, the law still struggles to ensure that only those who directly commit or make a meaningful contribution to a crime are held criminally responsible. This event powerfully highlighted just how urgent and unfinished that conversation remains. The event, titled Joint Enterprise on Trial, brought together legal professionals, researchers, campaigners, and affected families to critically examine the continuing use of consequences of the joint enterprise doctrine in the UK justice system. It was hosted by Mark Foot, Director of Appeal, and opened with a powerful lineup of speakers and performances that grounded the event in both data and lived experience. Dr. Nisha Waller and Tehreem Sultan, co-authors of the Central Research Project presented and launched at the event, shared findings from a detailed court observation study. Introducing the study, Tehreem, who was the first to address us, explained first the methodology used. Dr. Waller and Sultan observed multiple joint enterprise trials closely documenting prosecutorial strategies, evidentiary standards, and courtroom dynamics. Painstaking notes and data sheets were completed, not based on speculation, but on first-hand observations. Their work, they emphasized, is rooted in fact, not guesswork. She then shined a light on the numbers, which you can find detailed on their report, which is linked below from page 12 onwards. She emphasized how the data collected over just 6 months in a single Crown Court highlighted stark realities. Disproportionate prosecution of young black men, low conviction rates suggesting rampant overcharging, years lost in custody and court, often for those ultimately acquitted. Financial costs ranging from 1 to 2.2 million for remand prisoners who were never convicted. She then focused on social and systemic costs. She emphasized how these cases clog up courtrooms and fill prisons, often based on weak or speculative evidence. The doctrine is frequently used as a net to sweep up multiple individuals on suspicion alone. Tehreem raised troubling examples where presence alone was treated as guilt. Next in line was Dr. Waller, who focused on the themes emerging from their report, which can be found from page 17 onward. 4 urgent themes emerged from their investigation: excessive use of charging powers, prosecution relying more on assumption than fact, contradictory and vague claim from the prosecution, such as, for example, that some individuals, though are observed in CCTV doing nothing, are allegedly spares used in case the violence escalates. Judicial warnings to juries about prosecution overreach. The report also drew attention to institutional racism and institutional whiteness within the system. For example, a case referred to as Case 14 involving black defendants, all remanded in custody on charge of murder, was contrasted with Case 13 involving white defendants who were mostly on bail and charged with lesser offences such as manslaughter. These cases, they say, laid bare the inconsistency and racial disparity in how the law is applied. A very deep and interesting panel discussion followed with lived experience at the forefront. Leading this powerful panel was Dr. Patrick Williams, an independent researcher and scholar working in service to community groups, movements and organizations who are resisting the harms of the criminal legal system of England and Wales and Europe. The panel comprised of Pearls Lauren Wisdom, mother of a 16-year-old who was arrested and charged with a murder he did not commit, though eventually he was not convicted. She is also the founder and director of Say No to Joint Enterprise UK, an organisation devoted to supporting individuals and families caught in the web of the justice system, especially where joint enterprise is concerned. Reflecting on the ongoing impact, she shared, "Even now we are traumatized." She said, "My heart still races when I hear a car door opening outside the house, fearing it might be the police." Another panelist was Cliché, a young man convicted under the joint enterprise law at 15 and released from prison at the age of 28. He is an emerging artist. He draws from his personal experiences to create music that explores themes of social injustice.
Choices in his life, just choose the right ones. Can't we let bygones be bygones? I nearly fell onto my knees when I got life done. Can't we let bygones be bygones? Vanish, they're coming like magicians. My life I didn't plan it, but the judge don't wanna listen. Mom's hoping I'll manage while I'm stuck up in the prison dog. I swear I'm feeling savage, screaming fuck a politician. Feeling also damaged that they took away my existence.
He reflected, "We were kids, some in school uniform, yet we were all convicted of murder. The goal was to convict as many as possible." Next in the panel was Yusuf Soleh, a barrister at Furnival Chambers, who also sits as a commissioner on the Westminster Commission on Joint Enterprise. He shared the story of a 14-year-old boy convicted of murder despite CCTV showing him standing passively outside a taxi. Acquitted years later, the boy had already spent 5 years behind bars. Finally, Andrea Kumba KC, a qualified barrister and solicitor in Western Australia and chief executive of the Howard League for Penal Reform, spoke movingly of meeting young, mostly black men across UK prison, some as young as 13, convicted as secondary parties. "It's a damning indictment of the system," she said. The audience was also involved in a moving Q&A session. On healing and racial stereotypes, Pearls urged a deeper reckoning with racial bias. She said, "Healing must start with dismantling the mindset that criminalize black identity, our music, clothing, culture." Cliché added, "Reforming the law is vital, but healing must also focus on those still suffering in prison." On legal reform, Dr. Waller updated the audience on a private bill introduced by MP Kim Johnson, now absorbed into a broader legislative initiative. Yusuf Soleh highlighted the Westminster Commission's ongoing work to gather empirical evidence to push for change, with a report expected in 2026. On building collaboration, Andrea Kummer KC emphasized the need to support families navigating the system, while Pearls suggested, "Take your kids to court, let them see what happens." On education versus systemic change, Dr. Williams closed with a sharp reminder: the problem isn't our children, it's the system built around them. The event concluded with a special performance from a group belonging to Commonwealth, a political theatre company based in both Bradford and Cardiff. They believe in theatre being a tool for social change. Their website, linked in the description below, states, "Our ideas are rooted in socialist politics, working class background, a keen interest in contemporary music, theatre, art, design. The people that we meet, and an idealistic ambition to shift things. We see our plays as campaigns, as a way of bringing people together and making change feel possible. We, the audience, were treated to public interest, an immersive large-scale show which explores real cases of joint enterprise to confront racist and classist discrimination within the justice system. Public interest was created in partnership with Judgement, joint enterprise not guilty by association, as a call to action. Judgement was also present at the event. The show brought stories and data to life, leaving the audience not only informed but emotionally impacted.
So what is a joint in a price? What do you mean you got there that night? How can you say it was a part of that fight? The proof's right here, you see it with your own two eyes. How many set down never got released? Tell you now it's corrupted police. Could have been you, or it could have been me. Could have been her, or it could have been Graham. You don't know how long the appeal is. Sometimes I can't see through it. I'm blinded by the bullshit. I had a good upbringing. I mean, did the best, but I had bad company. I'm even worse influence. Guys who will sweet side talking truants. Hear me clear, don't misconstrue it. I'm not a statistic, I'm not stupid. They won't tell you how many been locked or evidence shots we could have been used. But I tell you now it's non-stop. Everybody won't stop making a front page news. Yo, let me expose the truth. But they trying to send my man down as a murderer. He weren't even there when he's bringing his proof. Know what to say in them interview rooms. I'm 16 times more likely to sit with the next man, so don't tell me it ain't deep. I realise that I'm trying to be empathy from people who ain't never been in these streets. I'm a loot, I'm going to the core. Don't judge me by my features, please. I'm a melanated man, but don't judge me like an IC3. So what is a joint in a price? What do you mean you got there that night? How can you say it was a part of that fight? When the proof's right here, you can see it with your own two eyes. How many set down never got released? Tell you now it's corrupted police. Could have been you, or it could have been me. Could have been, or it could have been. The force don't understand this angle, broken. So I'm a teacher, G. I'm Anakin Skywalking. Driven to the dark side, all by the system, see. You're me in a box, I already want to run in the can because I was in the right place at the wrong time with a neutral. You see how this ain't as fair as it seems? What do you think's going through all them heads and them innocent souls getting put on a stretch? What do you think's going through a mother's head when a daughter's getting sent down for a death? What do you think's gonna call from the press when they got a good story that's making them bread? What do you think all the kids have done that were playing in the parks and they made bare beds? Guilty until proven innocent, but they don't want to prove us innocent. After 6 years, they've been in the evidence. Show me the proof, show me the fingerprints. 93% is men. Don't think it can't happen to you, blood. POC's more likely to feel it. Don't think it can't happen to you, blood.
The whole event was a powerful reminder that joint enterprise is more than a legal doctrine. It's a social and racial justice issue demanding urgent reform. What we have covered today, from flawed evidence to controversial law doctrines, makes one thing clear. The justice system doesn't just need scrutiny. It needs courage, reform, and above all, truth. If these stories stirred something in you, don't let it end there. Share your thoughts below, subscribe to this channel to support the voices pushing for change, and stay with us as we keep hope and justice on repeat. Join us again as we sit and rise in this unique trial.